Welcome back. Today, we're embarking on a deep dive into, I think, a really fascinating corner of civil liability, intentional torts, and economic torts.
That's right.
This is the family of civil wrongs where the defendant acts not carelessly, but with specific intent. For you, the listener, our mission is to quickly master these highly specific liability rules and, maybe more importantly, understand the court precedents that define exactly how intentionality is proven in the real world.
Absolutely. And to achieve that mastery, we're going to perform a pretty rigorous analysis of the source material. We really have to establish the foundational concept of intent. First, it's the bedrock for, well, everything we'll discuss today.
Okay.
And then we'll systematically analyze landmark cases, the ones that illustrate these concepts across claims involving torts to person, torts to property, and then finally torts to economic relations. We need to focus less on just sort of reciting definitions and more on that crucial judicial analysis. How do courts actually do this?
Okay, let's unpack this immediately then, starting with that bedrock principle you mentioned. Before we even touch on battery or assault, what is the core principle defining intent in court law? And critically, how is that state of mind completely distinct from motive? People mix those up all the time.
They really do. So intent is established if the defendant acted with the subjective desire to cause the consequence, that's one way R, and this is key, with knowledge to a substantial certainty that the consequence would occur.
Substantial certainty.
Right. And here's the distinction. Hostility, anger, or desire to cause harm, that's the motive, and it's irrelevant for establishing intent itself.
Relevant. Wow.
Totally. You can have the best motives in the world. Maybe you're trying to help someone and still commit an intentional tort. Conversely, a benign motive is absolutely not a defense. And furthermore, we operate under the mistake doctrine, a good faith, or even a reasonable mistake of fact. It's simply not a defense. If you intended the act, the law basically says you intended the consequence that resulted.
That concept of knowledge to a substantial certainty, that seems like where the really difficult cases must live. It expands liability far beyond simply, wishing ill will on someone.
Exactly. It's a more objective standard in practice.
Let's test that powerful standard using the classic case, Garrett v. Daly. Everyone remembers this one from law school. Let's analyze Garrett v. Daly. First, what are the legally dispositive facts?
Okay, the defendant, who was just a 5-year-old boy, pulled a chair out from under the plaintiff right as she was in the process of sitting down. This caused her to fall, obviously, and suffer significant injury.
Just 5 years old. And what was the core legal issue here?
The issue was whether a minor, someone who might not have possessed, the subjective desire for the resulting contact or the injury, could still be liable for battery if he had knowledge to a substantial certainty that the plaintiff would attempt to sit where the chair, wasn't anymore.
So could that objective standard apply even to a child? What rule did the court apply?
The court applied the rule that intent for battery is satisfied if the actor knows with substantial certainty that their act will result in a harmful or offensive contact.
Okay.
And this rule is really crucial because it ensures tort law's goal of compensating the injured party is met, even if the actor is, say, too young to form subjective malice or ill will. The law only requires intent to cause the contact, not necessarily the specific resulting harm that follows.
That makes sense. So what was the court's analysis? How did they reason through the child's mindset?
Well, the analysis focused on the child's sensory and intellectual capacity. The court reasoned that even a 5-year-old child can possess the requisite knowledge of substantial certainty. It's not automatic, but it's possible.
Right.
If the boy knew the plaintiff was actively in the process of sitting down, then his act of moving the chair demonstrated he knew, with substantial certainty, she would contact the ground instead of the chair.
And the conclusion, what did they decide?
The court held that the intent element of battery could absolutely be satisfied by substantial certainty, even for this child. They remanded the case, sending it back down for a specific finding on the boy's actual knowledge at that critical moment. Do you know she was sitting?
Okay, so intent established, either by desire or substantial certainty. Now let's look at what happens when that intent misses the target entirely. This is where it gets, I think, really interesting. Transferred intent. What is the specific doctrine of transferred intent, and what are the 5 traditional trespass retorts it applies to?
Right, transfer intent. It's a specific legal fiction, really, used exclusively for these historical trespass torts. It allows the intent to commit one of these torts to transfer either between victim, so person to person,
Uh,
or between the specific torts themselves, tort to tort. The five traditional torts it applies to are battery, assault, false imprisonment, trespass to land, and trespass to chattels. Only those five.
we definitely need to see that person-to-person transfer in action. Let's look at Talmadge v. Smith. This case really shows us the legal policy that essentially you don't get a do-over just because you hit the wrong person by mistake.
Exactly. It's about the wrongful intent existing in the first place.
Let's analyze Talmadge v. Smith. First, what are the legally dispositive facts?
Okay, here, the defendant threw a stick. He intended to strike one boy, let's call him boy A, whom the defendant believed was trespassing on his property.
Yep.
But instead, the stick missed boy A and struck a second, unseen boy, boy P, causing a pretty serious eye injury.
Ouch. So the core legal issue.
The issue is straightforward. Could the defendant's clear intent to commit a probably battery or maybe assault against his intended victim, boy A, legally imputed or transferred to the actual battery suffered by the unintended victim, boy P?
What rule did the court apply to make that transfer happen?
The court applied the rule of transferred intent, specifically the person-to-person kind. They essentially stated the principle that the intention follows the missile. The defendant is liable for the consequences of the injurious act if that act was intended against someone within the scope of those five torts we listed.
The intention follows the missile. That's memorable. What was the court's analysis then?
The analysis confirmed that since the defendant clearly possessed the wrongful intent, the hostile intent required for battery or assault against boy A, that legally sufficient intent was just automatically transferred to the resulting battery suffered by boy P. It didn't matter that he didn't know boy P was there or intend to hit him specifically.
And in conclusion, liable.
Yes. The court held the defendant liable for the battery against the unintended victim, boy P, squarely under the doctrine of transferred intent.
Okay, so we've seen how intent works with physical contact, even misdirected contact. Now let's see how the absence of physical force can still satisfy the intent element in false imprisonment. What's the prima facie case there, and specifically, what are the recognized means of confinement beyond just locking someone in a room?
Right, false imprisonment. The prima facie case requires 1, an intentional act by the defendant. 2, that act causes the plaintiff's confinement or restraint. 3, the confinement is to a bounded area. And 4, the plaintiff is either conscious of the confinement or is harmed by it.
Okay, bounded area, conscious of it.
Exactly. And confinement can be achieved through obvious means like a physical barrier or force, certainly. But also, interestingly, through an omission where there's a legal duty to act. Think of that classic case, Whitaker v. Sanford, refusing to let someone leave a yacht when you have a duty to provide means of escape.
Right, the yacht case.
And critically for our discussion, confinement can also be achieved by the improper assertion of legal authority.
Ah, that's the subtle one. The assertion of authority. It's a form of restraint that, I think, often catches people off guard. Let's test that using McCann v. Walmart Stores, Inc.
Good example.
Let's analyze McCann v. Walmart Stores, Inc. First, what are the legally dispositive facts?
In McCann, a family was stopped by store employees inside the store. The employees detained them based on an incorrect belief that they had shoplifted earlier.
Incorrect belief, okay.
Crucially, the employees told the family they were calling the police, and they physically stood in a way that blocked the family's path to the exit. But, and this is important, they never used explicit physical force or made threats of actual violence.
So just words and positioning. And what was the core legal issue then?
The central issue was whether confinement could be established solely by the employee's implied threat, we're calling the police, or this improper assertion of legal authority, combined with blocking the exit, all without any actual physical restraint or a formal arrest taking place.
Can that be enough? What rule did the court apply?
The court confirmed that yes, confinement absolutely does not require physical force. It can be achieved by the improper assertion of legal authority, provided, and this is the key, the plaintiff reasonably believes they must submit to that apparent authority.
Reasonably believes.
Yes. Now, this often bumps up against the shopkeeper's privilege, which does permit reasonable detention for suspected shoplifting. But here, the detention was ultimately found to be unreasonable, partly because the suspicion was mistaken and perhaps due to the manner or duration.
So reasonableness is key. What was the court's analysis of whether the family reasonably felt confined?
The analysis focused entirely on the context. The employee's statements about the police coming, combined with them physically blocking the exit path, reasonably implied to this family that they were, in effect, legally compelled to stay.
Right, you wouldn't just walk away if someone said they were calling the cops on you.
Exactly. And since the family did submit to this apparent authority rather than trying to leave, the confinement element was satisfied.
And the conclusion: Walmart was liable.
The court concluded that the evidence presented was sufficient to support the jury's finding of false imprisonment, based primarily on that implied assertion of legal authority.
Okay, that's clear. Now let's do a couple of visceral hypotheticals just to really lock in some of these doctrinal distinctions. First one: suppose a disgruntled chef intentionally spits into your glass of water at a crowded restaurant. Gross, I know. But you drink the water entirely before you realize what happened. Is this battery or assault?
Ooh, okay, analyzing the hypo, this is a textbook battery.
Battery. Why?
Because battery only requires an intentional act that causes offensive contact. And offensive contact is legally defined as contact that offends a reasonable sense of personal dignity. Spitting in someone's drink, which they then consume, that absolutely qualifies as offensive contact.
Okay, makes sense.
Now, crucially, since you were completely unaware of the action before the contact occurred, you drank it without knowing, the essential element of assault, which is the plaintiff's awareness or apprehension of imminent harmful or offensive contact, is completely missing. No apprehension, no assault, just battery.
That makes perfect sense. The law punishes the offensive contact itself, not necessarily the fear beforehand if there wasn't any.
Okay.
Okay, let's move to property torts with the second hypothetical. A neighboring copper smelter continuously emits millions of microscopic invisible particles that settle onto your property every single month. For years, you never notice. But eventually you discover the cumulative pollution has subtly, but let's say demonstrably reduced your property value.
Yeah.
Has the smelter committed a classic case of trespass to land?
This is a great one because it shows how courts draw lines for tangible versus intangible invasions. What's fascinating here is the traditional rule versus the modern exception. The traditional rule for trespass to land is strict liability, essentially. Intentional entry onto the land is the harm. You generally don't need to prove actual damages. A footstep is enough.
Right.
However, for invasions by microscopic, undetectable particles, like the ones from the smelter courts, following the logic of cases like Bradley v. American Smelting and Refining Company, make a really significant departure from that old rule.
How so?
They require the plaintiff to prove actual and substantial damages to establish liability for trespass by these invisible particles.
Ah, so no harm, no foul for tiny particles.
Pretty much, it prevents, every speck of dust crossing a property line from becoming a lawsuit. But in your hypothetical, since you can prove reduced property value, that's actual substantial harm, the requirement for trespass by microscopic particles is met. So yes, liability could be found there.
That provides really critical policy context for the property rules, preventing absurd results.
Okay, let's now shift our focus entirely to an economic tort. Fraudulent misrepresentation. What are the key elements of the prima facie case there, particularly focusing on the sometimes insidious role of a half-truth?
Right. Fraud or deceit. It's a big one. The claim has 5 key elements you have to prove. 1, a material misrepresentation made by the defendant.
Material.
2, it has to be made with scienter. That's a legal term, meaning the defendant either knew the statement was false or acted with reckless disregard for whether it was true or false. It's a mental state requirement.
Got it, scienter.
3, there must be an intent to induce reliance. The defendant wanted the plaintiff to rely on the statement. 4, the plaintiff's reliance must have been justifiable under the circumstances. And 5, the plaintiff must have suffered pecuniary damages, meaning actual financial loss.
Okay, 5 elements. And the half-truth, how does that fit in? A half-truth is absolutely considered an actionable material misrepresentation. It's a statement that is maybe technically or literally true, but it omits crucial qualifying information. And that omission creates a false overall impression. It's deceptive because of what's left out.
Deceptive by omission. We definitely need to see how the court handles that kind of critical context being left out.
Wow.
Let's analyze Jacobson v. Hofgaard.
Perfect case for this.
Let's analyze Jacobson v. Hofgaard. First, what are the legally dispositive facts?
Okay. In Jacobson, a seller advertised a property as newly renovated. And while that part was literally true, renovations had occurred.
Sounds good so far.
However, the seller intentionally failed to mention some pretty material facts, namely that the renovation included serious, uncorrected zoning violations and also involved extremely shoddy workmanship. These issues effectively made the property unusable, or at least require very expensive remediation despite being newly renovated.
So renovated but not legally or practically useful. What was the core legal issue then?
The central issue was whether that literally true statement, newly renovated, could still constitute a material misrepresentation if it deliberately concealed these critical negative facts that rendered the overall implied representation, the implication that the property was legally compliant and structurally sound, completely false.
Can truth be fraudulent? What rule did the court apply?
The court applied the rule that yes, a statement, even if true in isolation, is a material misrepresentation if it qualifies as a half-truth. That is, if it omits necessary qualifying information that's needed for a complete and accurate understanding of the situation.
So what was the court's analysis of the newly renovated statement in context?
The court recognized the inherent context of a property sale. Labeling something newly renovated in that specific context carries a very strong implicit warranty, or at least representation, of legality and usability. Buyers expect that. Therefore, the deliberate omission of the major zoning violations and the substandard quality satisfied the element of material misrepresentation. Why? Because the seller clearly acted with the requisite scienter. They knew about these problems and intended to create a false, misleading impression to induce the buyer to purchase.
And the conclusion, fraud.
Yes. The court found that the literal truth of the newly renovated statement did not prevent it from being a fraudulent misrepresentation due to those deliberate material omissions. The half-truth was enough. So if we try to connect all this back to the bigger picture, maybe for someone studying this, analyzing intentional torts successfully really requires a strict step-by-step diagnostic checklist. You can't just look at the final injury. You absolutely must analyze the defendant's subjective state of mind first.
Right. Start with intent.
Exactly. So here's a kind of 4-step framework for issue spotting intentional torts based on what we've just discussed from the source material.
Analyze intent. Always start here. Did the defendant act with desire to cause the consequence or with substantial certainty that it would occur? And if the intended consequence was aimed at anyone or involved any of the 5 trespassery, torts, battery, assault, false imprisonment, trespass to land, trespass to chattels, immediately consider if the transferred intent doctrine applies.
Okay, intent first. Check for transfer.
2. Torts to person. Once you've analyzed intent, ask, was resulting harm actual contact? That's battery, even if it was just offensive, not physically harmful. Or was it apprehension of imminent contact? That's assault. Or was it confinement? False imprisonment. And if it looks like confinement, double check if the means of restraint was improper, paying special attention to submission based on a false assertion of legal authority, like in McCann.
Person torts. Contact, apprehension, confinement. Got it.
3. Torts to property. Was there an intentional entry onto land? That's trespass to land. But remember the Bradley exception we talked about, requiring actual damage for those microscopic, invisible particles. Or was there an intentional interference with a chattel, someone's personal property? Remember that the degree of interference is what separates mere trespass to chattels from the more serious tort of conversion, which is essentially treated as a forced sale of the item.
Property. Entry on land, interference with chattels, check the particle rule and degree of interference.
And 4. Economic torts. Did the intent involve misrepresentation? If so, check for all 5 elements. Material misrepresentation, including half-truths, scienter, intent to induce reliance, justifiable reliance, and pecuniary damages. Or did the intent involve interference with a contract or a prospective business relation? For those, always be sure to check for applicable defenses or privileges, especially the privilege of fair competition in business.
Economic torts. Misrepresentation or interference. Check all elements and defenses. That's a really useful framework. So after all this, what does it all mean? We've got through some pretty complex case law here to define the core idea that intentional torts primarily punish a specific, often sophisticated state of mind, not simply the resulting physical damage or economic loss. The law seems to care less about why you acted, your motive, and far more about what you knew or desired would happen when you acted.
That's a great summary, and maybe a final provocative thought to leave our listeners with. We learned, especially touching on fraud, but it applies elsewhere, that the difference between, say, a simple breach of contract and something more serious, like a tortious breach of the covenant of good faith and fair dealing. Think of an insurance company wrongfully refusing to pay a perfectly valid claim just to save money.
Yeah. That happens.
It can be immense. It can mean the difference between getting simple financial compensation, just your contract damages, and potentially recovering massive punitive damages, plus damages for emotional distress. So it raises an important policy question for you, the learner. If the public policy goal of tort law includes deterrence, how often should we allow what looks like a standard commercial contract dispute to sound in tort, to be treated as a tort, just because one party, like an insurer, holds disproportionate bargaining power over the other? When does bad faith breach become a tort? That's a really thorny concept worth mulling over.